Hello, everyone. This is Scott Schneider, a member of Husch Blackwell's Higher Education Group. We are excited to be talking with you today about restorative justice as a response to campus misconduct. Before we begin, I'd like to convey a few housekeeping items. At the bottom of your audience console are multiple application icons for your use during the program today. I would like to take a minute to highlight a few of the key icons for you. First off, if you have any questions during the webcast, please submit your question via the question box. We're going to try to answer all of the questions that we get during the webcast today, but my goodness, we have a lot of material to cover in a short period of time. I can promise you if we don't answer it during the course of the webinar, the three of us will respond via email to the question. We truly appreciate audience participation and encourage you to submit any questions that you might have. There's also an icon to assist you with viewing preferences accordingly. Please note that you can expand your slide area by clicking on the maximize icon on the top right of the slide area or by dragging the bottom right corner of the slide area. If you have any technical difficulty, and I hope you don't, please click on the help icon. It has a question mark and provides information regarding common technical issues. A copy of today's slide deck and additional materials are available in the resource list icon that looks like a folder at the bottom of your screen. This program has been approved for Colorado, Illinois, Iowa, Indiana, Kansas, Missouri, Nebraska, Tennessee, and Texas continuing legal education credit. Wisconsin credit is pending. To report your hours in Illinois, Indiana, Kansas, Nebraska, Tennessee, or Texas, click on the CLE widget at the bottom of your screen and complete the questions. A recording of the webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you along with a certificate of attendance. The recording will be available for 2 weeks. I am now off script, and joining me today, I get to introduce two of my favorite people. First off, joining me today is Paige Duggins-Clay. Paige is my fantastic colleague in the Austin office. Don't know what I would do without her. She's done a considerable amount of education-related litigation and perhaps more importantly, has helped universities in Texas and throughout the country design comprehensive programs to assist those schools in thoughtfully addressing any number of complicated challenges, including responses to sexual misconduct and items like that. David Karp, who I've had the pleasure of knowing now, I think for about several weeks, is fantastic. I've seen a lot of his webinars. I'm super excited to be participating on this one with him. David is a professor and director of the Center for Restorative Justice in the School of Leadership and Education Sciences at the University of San Diego, where the weather is always terrible. His current scholarship focuses on restorative justice in community and educational settings. And so with that, I want to provide, I think, a little bit of my perspective, our perspective on this topic, and then sort of just jump right into the meat of this. And so first off, I think the reason why this conversation is important, and this is informed by time I know I spend, Paige spends, David spends on college campuses meeting with participants in our traditional investigatory, adjudicatory models, and also being involved in the really painful litigation that is associated with these sorts of cases, is that there's this general sense of almost universal and frankly deep-seated dissatisfaction with the investigatory, adjudicatory model for dealing with student misconduct. Now, with that said, I think there is no appetite for a return to sort of the mishmash of informal practices and informal resolutions that schools engaged in and probably reigned prior to the 2011 Dear Colleague letter from the Department of Education. And so one of the questions I know personally I've struggled with, based on all of the years of doing this work and meeting with people and talking to people, is there an alternative to this investigatory, adjudicatory model, which is rigorous, number one, and more in line with the educational role of colleges and universities? And specifically, the part where colleges and universities are supposed to, in essence, be socializing people for their participation in the larger community, identifying bad behavior, educating, and changing that behavior. And so that's why I think this program is super exciting. I will say this: there has been a lot of discussion about restorative justice, and I put it in quotes, but little understanding, I think, of the rigor that is involved in creating a thoughtful restorative justice program. And with that as backdrop, I'm super excited to have David Karp with us. He is going to go right into what restorative justice is and what these programs, when they're thoughtfully done, look like.
Thanks, Scott, and hello to everybody out there in the interweb. I wanted to just briefly tell a story as a quick introduction to what restorative justice is, and then also you'll see a quote by one of the pioneers of restorative justice, Howard Zehr. This is probably the most popular definition of restorative justice. So I want to talk about this image you see of this horse. It was called Spirit Horse, and it was maybe the first case that I facilitated many years ago. It involved this horse, which was part of a public arts project in the town I was living in, where artists were sponsored by local businesses to do artistic things to fiberglass horses. In this case, the artist called this Spirit Horse because he had the front half of the horse on the outside of the storefront window and the back half inside, so it was mystically coming through the window. It also had, you can't see it here, but glowing eyes. So it was pretty cool enough that a very drunk student at my college decided to steal it, and really got about 50 yards before he was arrested. So we were dealing with a disorderly conduct theft situation. For a restorative process, what we did fundamentally is ask who was impacted by this offense and invite them into a collaborative decision-making process so that the student could be held responsible. There were two moments in this process that stood out for me even many years later. One was when the artist was talking about how he was impacted by this. He, of course, talked about the vandalism to his art, but more so, he said that when he got the call, he went down to the scene of the crime and discovered that there were the two live wires that had been attached to the glowing eyes left on the street, and all he could think about was that someone could have gotten injured, whether it was a toddler or a dog being walked, and that was his primary concern. And that left a deep impression on the student that this artist was primarily concerned with the well-being of others. So that was a really, I think, significant moment, and one that couldn't have been predicted. The other moment that was noteworthy was the Arts Council director, who had conceived of this broader project, was very angry with the student and really wanted to see some kind of harsh punishment to set an example to other students about how unacceptable his behavior was. At some point, the student said the reason that he tried to steal the horse was that he had worked in his own hometown's public arts council the summer before, and in his drunken state, he just wanted a memento of this event, which he really liked. And he recognized this was not the best way to express his appreciation for the arts, but the director was taken aback. She just assumed it was straight up vandalism. And when she learned of his somewhat good intentions, she said instead of the punishment she had originally asked for, which was jail time, that she wanted him to work for her as a community service effort, and that she would supervise him. So there was a significant turnaround in their relationship. So I wanted to highlight this story just briefly up front to give you an example of what a restorative process looks like. And I'm going to turn it over to Paige.
That's great, and I love when David tells that story because it really highlights some of the most important kind of fundamental differences between a restorative justice process and our traditional conduct, or what we often call model code processes. The first thing you'll kind of notice from that story is at no point was David talking about a specific rule or policy violation. I mean, we know what the underlying charges were from a criminal justice perspective, but the student quickly accepted responsibility and acknowledged this is something that has caused harm. And so that's a key defining kind of characteristic of this process just from the outset is we're not looking at what part of our policy are we engaged in an investigation under. We're asking what was the harm, and who is responsible for it. The second kind of defining feature that we're looking at is under our traditional processes, we're talking about what steps are we going to take to gather the evidence, to investigate and adjudicate this process? How are we going to determine if the policy was violated? This is, again, very different from a restorative justice process. Where that step is already complete, we're asking the person who we know caused the harm to accept responsibility. And rather than kind of going through the kind of long process of investigating, we're spending that time figuring out what can they do to accept it, and how can they repair that harm? And we saw that play out in the Spirit Horse story with the student engaging in community service. I believe in that case, the student also paid some restitution for the vandalism done, and organized some activities on campus to bring awareness of the misuse of alcohol and how it can contribute to these unintended consequences. And that last point really goes to kind of the third kind of defining feature of restorative justice, which asks, how can we rebuild trust between the person who caused harm and the person and the community? And I think what's so great about the Spirit Horse story is it shows that it's not just the campus community and it's not just an individual complainant that often experiences harm. That's often the case, and certainly when we're getting complaints in areas such as Title IX and other direct kind of misconduct cases, we're focused on responding to the needs of that complainant. But as David kind of highlighted, there was reputational damage to the university with trying to work through. We have this greater community exhibit. We've got students out there kind of putting the university in a bad light. Restorative justice addressed that, and by doing community service, helped build that bridge back to the community. Similarly, the student involved was highlighting a greater, more societal issue of how are we using alcohol and how is that contributing to bad problems. And by creating that programming and allowing that for the campus community to have a dialogue, showing that individual who had caused harm was capable of reformation. And that's not really something that we're always thinking about, at least in the four corners of a traditional investigation and adjudication process. And all this really gets back to the main point here, one of the main points, which is restorative justice is truly an educational process and opportunity. With that, one of the questions I'm certain everyone out there has is, why would harmed parties even consider participating in this process? You know, and we hear this a lot. We advocated for years and years. We got the Dear Colleague letter. We got these really rigorous investigative process in place to bring justice. why would we go back to, quote unquote, a process that's more informal? So I think we should spend some time talking about that. We know, all you folks out there, we've got a great mix of Title IX coordinators, general counsel, support people. We all know that the traditional investigative processes can be long and probably even more important, intrusive. Whether we're talking about misconduct of the nature that David described, kind of a non-discrimination-based misconduct, maybe that's easier to resolve, but particularly when we're talking about anti-discrimination claims such as Title IX, these get really personal, and particularly when we're dealing with sex misconduct. We know that one of the greatest complaints that participants in our process have, and especially complainants, is we're being re-traumatized. We're being asked to tell our story over and over again, first to an initial intake person who then has to report it, then to maybe the Title IX coordinator, then to an investigator, and potentially again to a hearing or adjudicatory body. It can all be undone and have to go through the process again through an appeal. This is not a process that is appealing for many people, and certainly not the vast majority of our students who are young people dealing with these really difficult issues. In that same vein, we're looking at a process under the proposed regulations and even if you're our friends over in the Sixth Circuit, where we're dealing with direct confrontation and cross-examination by attorneys. This is a process that's intimidating, frustrating, and worrying for a lot of folks on both sides, but we hear this particularly understandably from the complainant perspective. One of the other really interesting things we hear about this process, and I'm certain that the folks out there listening have heard this too, is when we're working with complainants, and particularly in Title IX matters, one of the reasons that we're hearing that people don't like to come forward is, I'm really worried about how this is going to impact my friendships and the people who have social relationships. The reality is, we know that the vast majority of victims of sexual assault in particular are probably going to know the person who caused harm. It's very likely going to be someone in their friend group. It may be a person they have a relationship with. And we know that one of the reasons they might not want to come forward and participate in the formal process, and by formal we mean investigative process, is because they understand that that process is not going to impact them personally, but also impact people they care about and the social dynamics in their groups. These are legitimate concerns, and restorative justice offers a really excellent reason, a really excellent way of addressing some of them. To that point, go ahead.
Yeah, I'm here. So we want to highlight the idea that it's not our intention that restorative justice necessarily replace current adjudication systems, but rather offer it as an additional option. And I think this graphic says why. In a fairly recent study by Holland and Cortina, they surveyed 834 female students at a Midwestern university, and 284 of them indicated that they had experienced sexual assault during their time at the university, but only 16 of them reported it to anybody on campus, and then only 5 of them filed a formal complaint leading to a hearing. So for the vast majority of students, 98%, they are not availing themselves of of the resources that we have available. And so what we're really saying is that by offering restorative options, we might be able to serve many, many more students in need.
That's exactly right. And the flip side of that is asking, well, why is it that people who are accused of misconduct would participate in a variety of types of misconduct, but again, particularly with allegations of sexual misconduct, the stakes can be really high. And so we have to ask ourselves, what exactly is a good reason for respondents to participate? I think the most important reasons is we have these very selective processes. We have admissions process for getting really qualified students into our classrooms, into our buildings, and we really believe that they're going to be good participants in our educational programs. And the reality is lots of these students really are looking for an opportunity to accept responsibility in a way that the traditional investigative process doesn't allow for. And similarly, in line with our educational mission, once confronted with allegations or understanding that they caused harm, many of our students are willing and open to considering how they can learn from it and how they can not repeat the conduct. And I highlight those because they're the most important considerations from the institution's perspective on why we should consider offering these an opportunity to engage in a restorative justice process to our respondents. As a practical matter, in terms of encouraging respondents to participate, I think it's very attractive that it's a non-adversarial process. I think when you get, from the moment you get that first notice letter that from the Dean of Students office that you've been accused of misconduct, the stakes feel very high again, and it can feel very overwhelming and scary, and you've kind of got your defenses up. Creating a space where you can come in, be confronted with the alleged conduct, and acknowledge the harm that that conduct caused might be a much more productive way of dealing with that misconduct as opposed to raising the stakes right from the outset. And a less kind of, not a less important, but a final kind of consideration is that in line with our educational processes and standards, many of our students are just looking for a way to get back into the community. They understand that when they've been accused of misconduct, and especially misconduct involving discriminatory complaints, that they are going to be labeled. They're going to be labeled as a sex offender or a person who's not desirable in the community. And part of our educational mission is to try to, where it's appropriate, to create space for reentry. And we'll be talking about some ways that restorative justice can help with that too. The final, I'm sure we've convinced you at this point that restorative justice is great for everyone, but if you're still wondering why would a school think about this process, here are a couple of reasons that we thought might be persuasive. Overall, I feel like we've hit this point over and over. We're educational institutions, and RJ really tends to fit that mission and goal much neater than a traditional investigative and adjudicative process. And I think what David highlighted just a few slides ago about creating those opportunities for more students to come forward is perhaps even more important. To the extent that we've got students out there not able to access educational opportunity because of these sorts of allegations, and they're not coming forward, they're not getting resources, and the institution's not having an opportunity to engage with them and assess how they can better serve communities, this is a way to make that happen in a way that's comfortable for our participants. We're going to talk about some examples on these last two, but the practical considerations are, if we do this effectively, it might actually be a better use of our resources. We all know the time and energy and resources, both the human resources and the monetary resources of investing in a comprehensive investigative and adjudicative process. We're talking about bringing in our professors to sit on hearing panels, hiring and training our investigators, doing the appeal process. This is a bunch of labor from the institutional perspective, and it's certainly a worthwhile investment, but to the extent we can offer an alternative that's going to maybe alleviate that, might be a good reason for considering this process. And another really great reason is if you do the restorative justice well, it's very likely that you can increase satisfaction with your process and the outcomes from that process. And David's going to give us a couple of examples of why that is.
Well, this slide shows some findings from a study I did a few years ago with essentially a survey of 18 different campuses that were willing to share some data with me, and we compared more traditional conduct process with restorative process. And the focus of this one was this graphic is the learning outcomes for student respondents. And I would say we are not talking here about the contrast between a very punitive process versus a restorative process, because student conduct administrators are already deeply invested in the learning and development of students. And the findings show pretty consistently that a more traditional approach, often characterized by a motivational interviewing framework, leads to pretty good outcomes. A fair amount is the rough mean score for these different types of outcomes. But what happens when you include harm parties in the process, the student learning just goes up a whole other level and across the board. So there's a good indication here that students who cause harm benefit greatly from the process. Before I talk about this slide, I want to mention that we have also plenty of data on the positive impact on harm parties in the community. This slide is references Paige's earlier point about the labor involved with adjudication. The College of New Jersey has been doing work on Title IX cases and compared their restorative process with their formal hearing process and tried to track the number of hours associated with each one. And was essentially surprised to find that the restorative process was more efficient. But maybe others who are intimately involved in Title IX hearings are not surprised at how labor intensive those can be. So we're not really talking about adding a process that is more time consuming than what we're already doing, but may gain some efficiencies.
Absolutely, and we'll get to this point a little bit later in the program, but I wanted to highlight one of the really interesting data points that David's study and the STAR report showed was that overall, students on both sides felt that the process was much more fair and the procedure and the outcome was much fairer. And we know from all of our experience that respondent Title IX litigation focuses on issues of due process and fairness. And so I think that's really interesting, and we'll flesh that out a little bit later when we talk about some of the legal issues. But for the time being, we're going to jump right in. I'm seeing a lot of questions in our Q&A, people asking and wondering about what does RJ look like? Is there a finding of responsibility? And a lot of the nuts and bolts question. And great, luckily for you, we're going to spend some time diving right in. I'm going to highlight or just preface this that this is a really deep process and there's lots of nuts and bolts and there's lots of things to learn. So it's going to be a surface level conversation, but what we hope that you'll come away from this is an idea of the big picture of myth busting of what does the restorative justice process look like.
Yeah, so I'll set it up just quickly and then pass the baton to David. I mean, I know the history of higher ed and student misconduct, and I think some of what the 2011 Dear Colleague letter was trying to do with respect to sexual misconduct is say, this old way of the way in which we informally handle these sorts of cases just isn't good enough. And typically what that would be is I have a conversation with one student, I then go have another conversation with another student. Maybe I convince a person accused of misconduct to go and leave the institution. Maybe they go to another institution, worst case scenario, and reoffend. And so, you can understand the policy rationale for the 2011 Dear Colleague letter. What I find attractive about the restorative justice process, and David will get into the weeds on that here, is it's not like that sort of informal resolution that, sort of was in vogue at a lot of institutions for a long period of time. This is a much more rigorous process than that sort of traditional informal model. We're providing notice of rights and options in compliance with the Department of Education guidance on these topics. It is a voluntary process that everybody, both complainants and respondents, need to agree to participate in. Participants, there's a lot of work, I think maybe less, as David indicated, less work than in the traditional investigatory, adjudicatory model, but there is work, prep work that needs to be done with participants before we get people together. And we'll talk about this later when we talk about the legal issues. Whatever comes out of this restorative justice process is memorialized in an agreement of some sort that once the restorative justice process is done, we're not done. We then need to monitor compliance with that agreement on a go-forward basis. So with that as backdrop, I think David was going to answer some of the nuts and bolts questions about what a restorative justice process looks like in practice.
Thanks, Scott. So one challenge to describing a restorative justice process is that there are many processes, many different kinds of practices that come from different parts of the world with different traditions and styles. So this is a bit reductionistic to boil it down in this way. Nevertheless, the most common model is called restorative conferencing, and it involves these three stages. The pre-conference process involves all of the activities from referring a case to assessing whether it's appropriate to RJ, to preparing the parties to participate in a face-to-face dialogue. It's a bit of a misnomer because many restorative practices are highly effective simply by engaging in a pre-conference process, and through shuttle negotiation, the parties reach an agreement without ever needing to come face-to-face. But it is quite powerful when they request that. And so when they do engage in a conference, it's a facilitated dialogue. They are asked fundamental questions about what happened and the harm and what could be done to repair it. And as Scott just mentioned, there's an agreement that gets reached ideally. And so there's a phase afterwards of agreement, monitoring and support, and assessment about the effectiveness of it, and mentoring, essentially, to make sure that the student continues to grow and learn from fulfilling the obligations of the agreement. What we fundamentally do in a restorative justice process is try to create space to identify harm. And there are different kinds of harms that are experienced in these kinds of cases, whether they're emotional harms or material harms, such as things that are broken or lost, communal or relational harms, such as disrupted relationships or community reputation damage, or broader harms that hover in the zone of social justice. So often we talk about microaggressions, and then they are often dismissed as micro, as small, as trivial. Why are we making a big deal about it? And from our perspective, we make a big deal out of it because even if the incident is small, what it does is inflame the underlying historical harms that have been experienced by disenfranchised people, and that we need to attend to these kinds of structural inequalities. So I wanted to give just another case example. This one is best understood by listening to the account by the students in this podcast called Reckonings. You can see the link. It's episode 21, A Survivor and Her Perpetrator Find Justice. These two students were engaged in a restorative process after Samir sexually assaulted Anwen. These are pseudonyms. The incident occurred during their first year as students, but Anwen did what we would predict, which is she told no one for several years. Spring semester of her senior year, she decided to report it, feeling like she couldn't graduate without something being done. But when she reported it, she asked for a restorative process and was not willing to engage in any kind of formal hearing process. The restorative process is a process, as I mentioned, to identify and address harms, and the kinds of harms that were identified in this case were first emotional. Her feelings of disgust. Anwen was a writer, and very literary thinker, and she described, for example, in very vivid terms that she experienced, quote, ghost hurt between her legs. And that speaks to her experience of emotional harm. And what she was seeking, particularly from Samir, was acknowledgement of the harm that he had caused. And the solution was his acknowledgement, his apology. She wanted him to read things she had written and write a response to her writings and to engage in the face-to-face dialogue. She also experienced disempowerment from that trauma, and what she wanted from it was engagement. So interestingly, or maybe unusually, she wanted Samir to engage in some public education kinds of things, and she wanted to present with him, alongside him, as a means to regain her sense of power and influence at the school that they were at. And also, Anwen was highly sensitive to the broader social issues around sexual objectification and wanted something done that would address that to reduce objectification. And so they devised together 3 different campaigns that were part of the agreement. One that was focused on addressing toxic masculinity on sports teams, in fraternities, of which Samir was a member, and a campaign to also do prevention work in a local high school. So the agreement itself looked like this, that Samir would read and respond to Anwen's writings. He would write an article for a student publication. They would present their story together at a bystander intervention workshop. They would collaborate on gender violence programming for athletes and fraternities. He would do outreach to peer victim advocates for some mutual learning and develop that sexual violence prevention program. So again, I encourage you to listen to them describe their experience with the restorative justice process. It's quite powerful.
Absolutely. And I think Anwen and Samir's story, I've also listened to it. It's very interesting, and I think it challenges us all to think about the types of misconduct that we might use these processes for. And, you know, we traditionally get a lot of pushback on using restorative justice practices in the Title IX space. And there's a lot of really good reasons to use caution before we move forward. And one of them is this. I'm sure many of you are familiar, in the wake of the proposed regulations getting announced last fall, a really thoughtful piece got published in the Time magazine. It was called Restorative, a Sexual Assault Survivor to Betsy DeVos, Mediation is Not an Option. And when we hear people talking about informal resolution and even about restorative justice, this is what we often hear. We don't want to have to confront or being forced to work it out, quote unquote, work it out is the dear colleague letter language, with our abusers. And this is totally legitimate, and we're spending some time unpacking. One of the really poignant things that came out of that article was that more survivors will be pressured into forgiving their rapists. Some feared that they would opt for mediation over informal and be pressured by the university into doing it. So we're going to talk about some of those legal issues about what it means for there to be voluntary participation, and to make sure that that voluntary agreement is sustained throughout the process. But distinguishing how restorative justice is different not only from our traditional investigative adjudicative models, but also from traditional mediation is super important. As David pointed out, there are some very important similarities. We're using trained professionals to engage in this really sensitive and difficult dialogue in whatever model we're using. Often we are using some mechanism for shuttle negotiation. You know, in mediation, it's almost always shuttle from beginning to end. And restorative justice, it might be a shuttle negotiation at the beginning as we're doing our pre-conference planning and kind of figuring out, identifying the harms and needs. And often we use the word mediation in both spaces. But that's kind of where the similarities end. In mediation, if you kind of imagine it for our lawyers out there, there's not really a guided or a structured preparation. Often it's in the legal context, it's an attorney, they read the case file, they do a risk management assessment of how much damages there are and figure out what the compromise, sweet spot is. But the parties themselves may not be doing that sort of preparation. In a restorative justice process, the preparation is for the parties. We're asking, how were you hurt? How can we make this right? What can be better? And that highlights another really important difference, which is in a mediation context, kind of inherent in the definition of mediation is this notion of compromise. And this goes directly to the critique offered in the Time article. This is not about, quote unquote, forgiving a rapist. In a restorative justice process, it starts from the central premise that a person must accept responsibility. In mediation, you don't always have to do that. It might be shared responsibility. There's a compromise. And restorative justice asks persons who cause harm to say, no, this one's on me, and this is what I'm going to do to make it right. Some other small points, of course, just bigger picture. There's focus on facts and evidence and what leverage do I have to get someone to yield a position. It's kind of a mediation approach. None of that is there in restorative justice. We're, again, focused on harms, making things right. And a lot of those trauma-informed safeguards that we hear so often, particularly of survivors of sex misconduct, are kind of built in to the restorative justice process. There's support persons, there's community involvement, there's substantial preparation, there's power in determining what the process should look like. And so these are reasons why restorative justice works, in our view, better than mediation in an informal resolution context.
Just very briefly, I wanted to mention that restorative justice is used not just to facilitate dialogue like we've described, but also for prevention efforts around addressing issues around broader community climate and around reentry, which is another really fraught area. And this image came from a protest that students held when a student who had been suspended for sexual misconduct was returning to campus. And so they were protesting the potential return of that student. And that just reminded me how anxious and angry a community can be after a hearing process occurs. And of course, students will continue to get suspended across the country and return to campus. And so restorative process is designed to simultaneously support the student's return to campus and address community concerns about their return in ways that we typically ignore, but really can't continue to ignore in an era when so many of these cases are highly public and online through social media. So we won't be talking about these particular processes here, just we wanted to note that they exist.
And before we jump forward to talking about some of these legal concerns, and I'm saying we're getting lots of questions about those, and I'm happy to say we've anticipated some of them and we'll work through them. David, I'm going to put you on the spot here because there's several questions about the mechanics of the restorative process, and one of them is, I think, a really, really important one. And I'll read it. In terms of taking responsibility for in terms of the person who caused the harm taking responsibility, is there a difference between acknowledging the harm caused and identifying and taking responsibility for the conduct that caused the harm? And I thought that was a nuanced, interesting question. I wondered if you could take a stab at that.
Yeah, I think this is very complicated territory. And in an ideal world, I would say no, we don't need to draw that distinction. But we live in a highly adversarial world where so much pressure on an accused student is towards denying responsibility. Their friends, their parents, their lawyers, they're all saying deny and minimize. So we have a culture that does not encourage people to take responsibility for harm. And yet we know that harmed parties are absolutely looking for that acknowledgement of responsibility. That's one of the most profound healing things that can occur is that acceptance of responsibility. So we're asking a lot of students when we ask them to take responsibility, and we're trying to create conditions where it's possible for them to do that. So one of the essentially workarounds, cultural workarounds, is to ask students to acknowledge causing harm, but not necessarily admit to violating policy. It's not ideal, but again, it's trying to work with the culture that we live in.
Thanks, David. That's great, and I think that's exactly right. And it's a nuanced issue that we're also working through. And I'm seeing a lot of questions about how do we accept responsibility in a culture where litigation, potential criminal prosecution, records retention requirements, and just lucky for you guys, we're about to dive into those right now.
Yeah, so I'm unlike Paige, I can't multitask, and I cannot use technology, so I have no idea what the questions are asking, and I want to keep it that way. Look, I think a lot of the pushback on restorative justice and the use of restorative justice in this setting has frankly come from lawyers and has come from legal concerns. And I think there are two ways of thinking about that. One is legal concerns on behalf of an institution. Is this an appropriate vehicle for dealing with serious acts of misconduct, and in particular acts of misconduct which touch on Title IX related issues, and also litigation concerns in particular for people, students, faculty, staff accused of misconduct. And look, we have a lot of thoughts about that. We'll navigate a few of those issues and give you some thoughts. Always happy to talk offline about it as well. Some perspective. Look, there's not a lot of case law at this point out there about how courts will resolve these sorts of issues. And so I think it's important to note that right up front. Paige, in a second, will talk about some of the cases that exist out there, but there's just not a lot of very clear guidance here. And I want to be clear, and I'll say this later, I don't know that restorative justice as an alternative, in fact, I'm quite confident saying that restorative justice as an alternative to the traditional investigatory, adjudicatory model, it's just not going to be appropriate in every case. And we'll talk in a second about what particularly would alarm me, and I would say, yeah, I'm not comfortable with it here. And I think the question is, are we comfortable with this person remaining a member of our community? And if the answer is, if they're found responsible for this, probably not, then perhaps restorative justice is not an appropriate alternative. I will say this, and Paige will get into the weeds on the cases. One of the key issues that you see courts focusing on, and I'll frame it here, is so we decide to use some sort of informal way of resolving a complaint, and let's say someone reoffends or harms at the institution, and what an institution is being looked at is, well, was that a deliberately indifferent response? Was that a clearly unreasonable way of resolving this particular student conduct matter, at least in the Title IX setting? And so two of the issues that really are highlighted in the cases that we'll just touch on briefly are, were the participants, in particular the complainants who came forward, were they participating in this process in a truly voluntary way? And I will say operationalizing that is to me a real challenge. You know, how do we document that they are participating in a truly voluntary way? How do we know they are participating in a truly voluntary way? How do we know at some point where this isn't truly voluntary anymore and this isn't appropriate? I think those are really interesting challenges. And then secondly, and you'll see in the case we discuss in a second, I mean, is this whole notion of if you're going to have a restorative justice process or a more formal, informal process, that we outline what it looks like in our policies and procedures, that it's sufficiently rigorous, and that we follow meticulously those policies and procedures. Paige, did you want to talk briefly about the University of California case?
Absolutely. And so Scott's exactly right. We did some research on this, and there's, maybe a handful of reported cases. And there's a pair out of the University of California system. And I think we've got someone from UC in the webinar, so this is not intended to be traumatizing. But it's a good case. So in TACLA, it's a 2015 case. A federal judge in the Central District of California denied the university's motion to dismiss a Title IX deliberate indifference claim where the plaintiffs, who were PhD candidates, I forget the program, they alleged sexual harassment by a professor. And I saw in the questions that there was a question of whether or not we can use restorative justice for faculty misconduct. And the answer is yes, but it requires some thought and some other considerations that we can get into via email. But in this case, it was very clear from the outset that it was not a voluntary process. The UC system has an early resolution process. It's memorialized in their policy. And from the outset, the plaintiffs said, we don't want to participate in an informal resolution. We want you to investigate it. We want you to deal with this. The court, in denying the motion to dismiss, highlighted 5 facts that supported his decision. I thought they were really great lessons learned for how we can, what we should be considering when we're implementing these programs. First one, UCLA handled the plaintiff's report through a truncated process called early resolution. Well, we looked at the process, at the policy. It's not truncated, but the effect was in administering it, there wasn't as much communication as the plaintiffs desired. And we see that as a repeated kind of complaint in some of these cases that tend to go wrong. The other key fact here was that the professor had previously harassed other students. So again, to Scott's earlier point, we had a person who was already kind of on our radar as a person who is engaging in this sort of conduct with others. And the policy here specifically said we will not use this process for repeat offenders. So that was ding number 1. The second one goes to that voluntary issue. In discovery, it turns out that the person administering the early resolution process really was strongly encouraging the plaintiffs to go down this informal process as opposed to pursuing the formal investigative process. And again, if that's part of our process, that's just wrong. It needs to be voluntary. And when you have a person in your office saying, "I want to go through with an investigative process," the answer to that very likely is yes. A third factor was that there was no formal report. And so I'm seeing some questions about how do we document. We'll get into that a little bit. But the policy required there to be some sort of documentation of how the early resolution process played out and how it was resolved. And again, as you're seeing highlighted in red, in violation of their own policy. The process took 9 months. This is a common complaint that we hear in our formal processes, and so to see that playing out in the early resolution process, again, just a missed opportunity there. As a final note, this is a common critique of what Scott has called pre-2011 informal resolution, which is you didn't even tell the plaintiffs what happened. And it's hard to know on the particular facts of the case and what's in a reported opinion exactly how accurate that was. But from the plaintiff's perspective, they weren't really advised of, at least in the way that they had hoped, of the outcome. And so in terms of meeting the complainant's needs, this one wasn't as successful. I will say that there's another case shortly after this one involving the same university, same system rather, same policy, and it came out the other way. And the court in that case found that the university followed its policy, met the needs, and granted a motion to dismiss. And the vast majority of cases that we're seeing involving informal resolution programs, that tends to be the outcome. If you're following your policy and doing it in a thoughtful way with trained professionals, that it can be a successful process that survives the deliberate indifference inquiry. I'm not going to spend too much time on this, but I thought it was interesting that there was at least one reported case of an informal resolution process that involved a restorative justice process. The case is Shanks v. Carleton College, and the plaintiff in that case, again, alleged deliberate indifference. The interesting nuance in this case was that the parties actually went through a traditional formal investigative process, and the respondent was found responsible for a Title IX violation. And the restorative justice process came after as a means of reintegrating. The plaintiff in that case, the complainant in the conduct matter, expressed serious concerns about having the respondent back on campus, which David alluded to earlier when we talked about reentry. But the court found that the plaintiff voluntarily participated. The university made the restorative justice reentry program available. They facilitated the process and found specifically that the process did not violate Department of Education guidelines that a complainant cannot be required to work out the problem directly. There was an important cautionary note there. This is a direct quote from the opinion. The court could hypothesize a different case where the meeting is not voluntary or the school knows or should have known that their ability to make rational decision is compromised. And so again, a good case for restorative justice, but also a cautionary note.
I'll briefly chip in on this one because I think it is super important. So, and I mentioned this earlier, informal resolution, restorative justice, it's not going to be appropriate for all cases. You see the factors, and I think if you're going to operationalize this and have a restorative justice informal process for resolving these issues, this needs to be part of your policy and process. What are the sort of cases where this is not appropriate? Look at the factors. They look pretty familiar, don't they? They are the same sort of factors that we assess in honoring requests for confidentiality. And I think it's entirely appropriate to say, look, if the nature of the alleged offense is so significant that we think this person's continuing on campus poses an ongoing threat to student safety, then an informal way of resolution is not going to be appropriate here. And arguably, you can see lawyers arguing maybe negligent or deliberately indifferent, et cetera. The last caveat, and I know we're running a little behind, is one of the important pieces of this is that in order to use this informal process, first off, it needs to be voluntary, but also that the respondent is acknowledging harm. And that is also an entry point for this informal process as well.
Yeah, and so how do we determine that participation is voluntary? I mean, we could spend an hour kind of working through these, but let's talk about some of the ways we can build in safeguards from an institutional perspective to help assess that, that issue. So the first thing is, we're not just launching a restorative justice program in a particular case. We're educating the parties and we're building a shared understanding of what that process looks like, whether it's through the use of what we call Tier 1 circles or introducing concept and orientation and other settings. We're giving people information about it as they come into our school. Again, it's an educational process. I think what's really important, and we're going to hit on some compliance considerations super quickly, but a restorative justice process has to fit within our existing compliance requirements. We're providing notice of rights and options. We're giving students information about whether and when the process can be used. Are there cases where we absolutely don't consider it? Even when we do start the process, when and how can it be terminated? And the most common arrangement that we see is, the process for any informal resolution can be terminated at any time by any party prior to a final resolution agreement being entered into. That's some of the common policy language that we see and work on. How are we going to use this information to the extent we go to a subsequent process? The answer to that is usually we don't. That's usually part of the agreement. We have confidentiality in order to help ensure the success of the process. We also, I think the most important way we ensure voluntary participation is we're engaging in the pre-work. we are meeting, your facilitators are meeting with the students and all the participants beforehand and constantly assessing, is this voluntary, is this participation meaningful, and is this going to work? And to the extent that the facilitator has the sense that it's not, we're making a recommendation to revert back to our more formal processes. We can, again, spend lots of time on this, but again, we're doing our best practice informal resolution compliance considerations. We're providing notice, as we discussed. We're providing that documentation of your rights and options. We're including information about restorative justice processes in those documents. And we're investing time in training the personnel or hiring even external personnel to ensure that the process is done effectively. And this has been another theme. Even after that final agreement is in place, we don't want to open ourselves up to liability because we didn't respond to a person saying that the agreement was not being enforced. And so that last point is really important. To the extent that we get complaints that a no contact arrangement or an educational part or any aspect of that agreement is not being complied with, we understand and the parties understand that the university can take steps to enforce it through its traditional conduct process. We've seen lots of questions about the implications for potential legal proceedings. What do we do if there's ongoing criminal justice concerns and prosecutions, especially in sexual misconduct cases? There's lots of different answers, and sometimes it depends on where you are. There's a credible argument that if we finesse these agreements well enough, the Federal Rule of Evidence 408 might cover this as a mediation or a compromise agreement. We're researching that and looking into that. You're seeing lots of states enact statutes specifically tailored to restorative justice programs, and Nebraska is one of them. Rhode Island, I think, has one. There's a few others that are really interesting, and they're specifically creating confidentiality for these proceedings. Another effective mechanism is engaging in an MOU with your local prosecutor, the DA's office. Our office and others have been working on modeled agreements that you can use to employ this. And so there's, a final point is often a precondition of participating is agreeing to confidentiality as between the parties. And so really making sure that the parties understand that what's said in the restorative justice process stays in that process is really important. And again, utilizing the institutional code of conduct to enforce that is important. We're out of time. I see that we're out of time. To the extent that you want assistance or information about how we can adopt and implement these programs, David Center and us here at Husch Blackwell will be happy to be thought partners with you. There's certainly a period of reflection, evaluating, and determining how to implement it and what conduct cases. And I think the point to be made here is we're not necessarily jumping in for the hardest cases. If you're interested in implementing restorative justice in your campus misconduct matters, maybe consider starting with types of conduct that may not be as inflammatory and might be easier to facilitate as you get your personnel and your community up to speed. So we're out of time.
I'm going to do a plug here, David. I'm going to do a plug for David. I'm going to say this, and David, you might not agree with me, but I'm happy to do it. This work is it's very rewarding work. I think it's also very challenging work, and there's no place for amateur hour here, and so that anybody involved with these programs in implementing a restorative justice program absolutely needs to go through some training. I'm going to do a plug for David's training, which you see some of the dates. I don't know if you wanted to talk about the dates, David, but they're on this slide. I highly recommend, I know Paige highly recommends these trainings. I think they're the best in the field. But if you're going to be doing this work, we want it done well. It's no place for amateur hour, and you really need to be, your personnel really need to be trained.
All right, and with that, we're sorry to have taken folks over time. We're seeing the questions. Please continue submitting the questions and reaching out. We're certainly happy to continue responding. And I'm a person who's also participated in these trainings and would be happy to do a plug. So I'll turn it to Scott to sign us out, and we're so grateful that you all participated in our webinar today.
Yeah, and I promise we will respond via email to the questions. I'm supposed to read this script. Thank you for joining us for our program today. We hope the information provided was helpful for you and your organization. If you haven't already, please click on the survey icon at the bottom of your screen to complete our short survey. Your feedback assists us in providing quality future programs. Just a reminder, a lot of states, Colorado, Illinois, Iowa, Indiana, Kansas, Missouri, Nebraska, Tennessee, and Texas. I'm going to be traveling all of these places over the next several months, but you can get continuing legal education credit there, and a recording of this webcast will be available tomorrow for watching and sharing. This concludes our webinar. Thank you all so much.
Thanks, everyone.